Developments like the new licensing regime for accountants and the future of financial advice reforms for advisors have made compliance a more important issue probably than ever before. With me today I have Christina Kalantzis from Alexis Compliance and Risk to talk about this matter. Welcome, Christina.
Thank you, Darren.
So I did mention FOFA, or the future of financial advice reforms, and one of the things that has come in with that is the best interest duty. So if we're looking at that subject in itself, what considerations do advisors and accountants for that matter now need to consider when giving SMSF advice?
What an interesting concept, this best interest duty. It's been something that's been around for a very long time, but it's actually enshrined in law now. And the ramifications of that, or the interpretation of what best interest actually means, we're getting some ideas of what that is in terms of practice from, if we look at the enforceable undertakings that ASIC's looking at, and also the recent banning orders as well. But when I go into a practice and I try to analyse what best interest duties are and how do you actually put that in practice for the accountants and the advisors, those engaged in giving financial advice, I'd be making sure that the client comes first. You prioritise the client's interests as well, and what I mean by that is if there is a perceived conflict, you need to manage that conflict. You need to disclose that conflict, or you may need to avoid that conflict as well. I also think my view is when it talks about best interest duty, I'd be looking at the remuneration structure and how you pay for the advice as well, how you charge for that advice. I know there's commentary out there that says that it's not about the payment structure, but I tend to believe when I represent clients in hearings, when we look at enforceable undertakings and banning orders, that ultimately does come down to the actual payment structure. So I would proceed there with caution in terms of that. Another thing that I'd be looking in terms of best interest is the client better off after the advice was provided, and have you articulated what that benefit is to the client?
Yeah. I suppose drilling down into a more specific area of advice, there's been a lot of talk obviously about insurance cover and risk cover.
Yeah.
Are there any different considerations that are needed there?
Definitely. Insurance is a hot topic at the moment, especially within self-managed super funds. And again, I would invite everyone to look at the enforceable undertakings, or we'll be discussing those anyway at the presentation, and the banning orders. And when we talk about the insurance cover, the main areas of interest is the affordability, the cash flow, and what does that insurance coverage mean at the end result for superannuation, because that is their retirement savings. So what I've found in the hearings that I've been attending, also the EUs and the commentary that's out there, if the advisor hasn't actually, the accountant or the advisor in the capacity of giving financial advice, hasn't articulated how the expenses associated with insurance and how that depletes a self-managed super fund or the retirement savings, we have an issue there that needs to be rectified, managed, disclosed, where the client is 100% sure that they know what the end effect is.
You just mentioned the word disclose, and my next question is about disclosure. Is there anything, a few specific things that you would recommend people to look at first in terms of disclosure? Okay.
Well, disclosure is on many fronts. One is the legal requirements to disclose in terms of the fees and commissions that you receive. There's also disclosure in terms of the risks to the client, so they understand exactly what insurance they're getting or what advice they're getting as well. A warning to the client on how the advice may impact their lifestyle, their needs and objectives as well needs to be looked at as well. Another issue when I look at disclosure, you can disclaim and disclose everything, but if the client doesn't understand what is happening and you don't articulate that in plain English, again, that's another concern for me when I look at the statements of advice.
Okay, you did mention enforceable undertakings before, and as we well know, ASIC is forever doing compliance checks and activity in this sort of area, and they've also already mentioned that they're going to be doing a shadow shop exercise for SMSF advice specifically. From the bannings and the undertakings, enforceable undertakings we've seen so far, are there any lessons that can be learned straight away from them to highlight things that people should look out for?
I'm at all when it comes to the enforceable undertakings and also the banning orders that have come out. The lessons that are learnt vary quite a lot. So what we think was appropriate advice or acted in the best interest in one client in 2014 changed in 2015, changed again in 2016 and changed again in 2017. So it's you have to be, compliance is something that you really, this is part of your core business now, and risk management is part of your core business. You need to be on top of it and understand what is required. So some lessons learnt really, and when we're looking at the shadow shopping as well, I would say proceed with caution about your file notes. They will protect you. The file notes are the things that actually evidence what you have done as well, and it becomes your understanding and also your advice process in terms of why the advice was provided to the client. Also, I'd be looking at all your research that was undertaken for the product that you recommended. Also, the research that was undertaken from the product that the client came from as well when you look at replacement product. So the fine details of having adequate good files is going to be paramount in terms of advice going forward. Whilst you might know everything in your head, my understanding is that ASIC's looking at the evidence trail. So IT systems are becoming more apparent now, so you have to make sure that everything is stored on your systems. We've got new record keeping obligations as well. You need to defend and design an advice document that can be defendable and evidenced as well in terms of why you came up with that advice.
Okay, Christina, so just say an advisor finds himself in an unpleasant situation of an ASIC investigation and it escalates. So it goes from a complaint determination into a misconduct issue. Yeah. What happens there?
Now, this is something that I want to make sure that all advisors are aware of. By law, the AFSL, or the licensee, needs to be part of an external dispute resolution scheme. So we are aware of that, and we've got 2 external dispute resolution schemes where the main advice providers are with at the moment. They also have obligations, though, to report a systemic issue or a pattern of behaviour in terms of the complaints they receive on an advisor to the regulator. And I'm not sure if advisors are aware of that. Now, once that pattern has been established, they may ask you to show cause and tell them why it's not a systemic issue. But if there's not reasonable grounds for that, then it goes to the regulators, and the regulators have got every right and duty to investigate that claim as well. Another thing that advisors should be aware of as well, that this is the supervision and monitoring of advisors goes beyond their licensee, goes beyond the regulatory environment. It also goes to the professional bodies as well. So if you're a member of the professional bodies, they too have their own internal enforcement arm as well. And then again, they will be put on notice in terms of any complaints that have been put on you. And again, you'll have to show cause in terms of whether or not misconduct was there or not, and why you are a fit and proper person to continue giving advice in the area.
So we've just touched upon a few compliance issues there. Christina will actually be presenting this subject on the SMSF Professionals Day, which is being brought to you by Self-Managed Super in conjunction with Super Concepts. So if you'd like to find out a little bit more about these compliance issues, which are very important, please come along to the roadshow that we're hosting. It starts on the 17th of July, it goes until the 27th of July. We start in Perth, but we are visiting all of the major capital cities in Australia. If you would like to register for the event, please visit www.smsfmagazine.com.au/events, and we look forward to seeing you there. Thanks very much for your time today, Christina.
Thank you, Darren, and I hope everyone comes along.